Ready? Start streaming.
Did good, perfect. Hello, everyone. I'm Chris Parker. No, we're not starting. Nope.
It's not on there yet. There you go. Now you're good. No news.
Good, perfect. Good morning. I'm Chris Parker. This is Kristen Ishihara. We're here at the Ishihara and Parker Law Firm here in Longview, Texas. And today we're covering an important topic that a lot of people want to gloss over or skip. What or how do we handle estranged children or child?
Yeah, and let's talk about what estranged means first. So in that, we can mean a whole bunch of things. Mostly, it really depends on your family, right? So if you have an estranged child because they separated from the family and don't contact you or had a conflict with something, so they're not interested in being a part of your life. It could mean other things, like it's a child from a prior marriage that you just don't have contact with due to the way the divorce went. It could be a child that you gave up for adoption. It could be any sort of child that's not involved in your family today. A lot of times that causes people to either think that that person will automatically not be included as part of their estate plan, and that's not true. Or if maybe it's a parent hoping to reconcile, it causes them to put off doing their estate plan because they're hoping that they can rectify that relationship before they make choices. And so we just want to talk about what the choices are, and that it is very important, though, to provide for that in your estate plan, and also to remember that your estate plan can always be changed. So as long as you're doing a will or a revocable living trust, whatever you put in place can be changed in the future if something happens to either heal a relationship or if a relationship was damaged with the current child. So nothing is set in stone. Everything can be changed.
Yeah, and so I look at it first of while you are living, right? While you are living and when you pass away. So while you are living, if you have an estranged child situation where there is a close child that you don't trust to make decisions or won't make good decisions for you, you need to get your power of attorneys done, and you need to nominate the right people or persons to serve in those roles. The last thing you want to happen is have some disaster happen to you, and this estranged child has been part of your life, has maybe caused a lot of drama and grief, suddenly comes riding to the rescue and fouls it up for the people who have been involved in your life for the last 10, 20 years. So I think the first thing you want to make sure is have your power of attorneys done and done correctly. Plenty of people pick their children, but if you have an unreliable or distant child or someone who shouldn't be there, then you need to make sure they are not in a position to do that, and you need to have your agents done correctly.
Sure, and I think the point that Chris is making is important to do before you become somewhat vulnerable or, maybe lose a spouse and have that opportunity. A lot of times there's grief associated with the loss of that relationship. And so as you age, if that person comes back into your life, or a lot of times what happens is that person's child, your grandchild, comes into your life, there's a tendency to want to overcompensate during lifetime with gifts or with other things. So having that conversation and putting those documents into place with, let's say you have 3 kids, one's estranged, with the 2 kids that are a regular part of your life, so they know what your expectations are, what you want, when you have capacity to make those decisions. So it's not grandma's 88 years old, having a lot of health issues. Her granddaughter from her estranged kid shows up for the first visit ever, and she feels compelled to buy her a car because granddaughter tells her a story about how their life has been really hard. Just talking through those scenarios is very specific,
Yeah.
but those things do happen, and it is often a grandchild from that estranged child that shows back up, and then it is a situation where you want to make decisions ahead of time, whether you'll be financially, overcommitting to that person, or how that plays out in your financial situation.
Yep.
Yeah.
So while you are living, making sure your power of attorneys are done correctly so the right people can help you at the right time, and so you don't have mistakes or people take advantage of you when you get older. The one that everyone thinks about, though, is at death or
Sure.
planning for death. How do we handle an estranged child situation? What can we do in Texas?
Sure, super important. And of course, up front, you need to decide, do I want to leave this child something? So we've got 3 kids, one's estranged. Is your will going to match Texas law, which would say 3 equal shares to those kids? Or do you want to decide, which you can always change your mind later, that you would leave a lower percentage or nothing to the estranged child? Some things to keep in mind here are, one, we always need to recognize the family relationship. So part of showing that you have legal capacity to put those documents in place is reciting your family information in the will, in the trust. So we don't leave that person out of listing your family information. You then have some choices on how you move on in the document. You can specifically disinherit them. Sometimes you've given somebody a lot of money for something and maybe it was a loan and they didn't pay you back and there's hard feelings. Or maybe you just covered a lot of divorce fees, criminal fees, whatever it is. You put out a lot of money for that child during that lifetime, so they're either not going to get something or they're going to get a lower percentage. Those are things that need to be included in there but not explained. So you're going to list the family member, you're going to determine what they get, and if they do get something, obviously you're not going to specifically disinherit them, but you might choose to include that language to be very clear.
Yeah, I mean, personally, when I'm doing ones, I love if you've got 3 children and one of them needs to be not included and them and their heirs are to be excluded, and there's basically 2 ways to do it. I have 3 children, and I'm only leaving things to 2 of them. Now, I personally like to say I've got 3 children. I am specifically disinheriting that 3rd child. They and their descendants are not to receive it, and then everything else goes in 2 shares to the other children. Obviously, that's an emotional decision. I've had a lot of clients say, "Oh, Chris, I'm mad at him or her. I don't want them to inherit, but golly, I just can't put that in writing in my documents." And I think, you're the boss. I would prefer to put it in there. Your executors who are receiving those assets one day would prefer it, but those are the 2 ways to handle it.
Sure. And 2 important things to remember. 1, you can always change it. So if that child comes back into your life tomorrow, you can change it tomorrow. There is nothing that stops you from changing it. And 2, you might consider a way to do it a little more privately. So Chris has mentioned a will. There are things like revocable living trusts that avoid going to probate. So if you have a will that leaves to 2 kids instead of 3 kids, your children will have to probate that will to transition assets upon your death to make that desire happen, because Texas law would say the 3 kids get it. Your valid will that gets probated at death is what would change the outcome of who gets those things.
Let me just, so there's one house. You have 3 children. Your will says it goes to the first 2 kids, but not the 3rd. When you die, if you have a will, your 2 children are included, must probate that will, or when the house is sold, it'll be divided 3 ways, not like 2 like you intended.
Right. And it has to be probated within 4 years, and ideally sold within that time frame so the executor can do it independently. So the way to potentially avoid that, where they have to probate it, because probate is an open proceeding where file-marked wills can be requested. So it is part of the court process that an estranged child or grandchild could come and get copies of things. You can do a revocable living trust, and we've talked about those before, but that would be a more private way to do that. Some other potential just yucky things that come up is if you did have a child that didn't realize they needed to probate the will and tries to do it 4 years after your death, they have to notify all the intestacy heirs, which means they have to serve with process that estranged child. They have to locate them. They have to have the citation taken to them by a process server or sheriff. And that kid gets notified that your will that doesn't include them is being probated 4 years after death. So it's pretty it's just kind of a not feel good situation there. So you can avoid those if you want to by doing a correctly done estate plan, which often in that scenario would be a trust because you have to probate it.
Yep. And those trusts are, of course, nice. They're going to be quicker. They're going to be more efficient. They're going to help the children avoid that. But again, I still run this problem where hey, Chris, I really want to do a trust. I want to make it easy on the surviving spouse. I want to make it easy on the kids. I want to do it all correctly. And why I'm mad, and I do want to mostly cut out this estranged child, I'm not yet ready to call them 100% quits, right? I've had many come in and say, I want them gone 99% of the way, but on the other hand, I want to make sure they get something. And I think that sometimes I see that reflected in wills and trusts where they leave them like $1. I'm like, don't do that. But I have had people have smaller accounts or things they want to do. Kristen, what's one or good ways to avoid that?
This is a real practical conversation you need to have with your executor. So let's keep using my 3 kids scenario. Let's say mom wants to leave, let's just say she wants to leave him a third. She hasn't talked to him in 40 years, but she feels really bad and she wants to just leave it in thirds to each of her kids. The situation that this creates for your good kid that's going to be your executor, your financial power of attorney, taking care of all of your stuff, the situation that creates for that kid is that when you die, they have to probate your will because he has to be the executor to handle everything. So when he does that, he can sell the house independently, collect all the estate assets. Immediately, though, after the will has been entered into probate, he's going to have to locate and give certified mail notice to that estranged child. So we do want to think about who your executor is, what their relationship is with that estranged child, and kind of the job that you're leaving them. So in that scenario, they have to know how to find that kid. They need to know how to get the address and the contact information because they're going to have to notify them that they're a beneficiary. So when this plays out really poorly is when you leave that estranged kid $1 or $1,000 and everything else to everybody else. You've really made the job of your executor pretty unpleasant because you could have just left them nothing, but you left them something, and now we've got to go poke them and say, hey, you got $1, you know.
Yeah. Good way for them to hire an attorney to then look into the case.
Right.
Yeah.
Not a good plan. But still really something I want you to talk through with that executor, because if neither of you have talked to this child in 40 years, it is a lot to ask for them to be able to do that. That child may decline to be found. They may not answer phone calls. They may not pick up certified mail. Now the executor has a sum of money that they can't distribute to that beneficiary. Sometimes they show up for money. Of course, that's true. Sometimes people pop up when it's time to receive some money, but sometimes they don't. For that child to say they don't want the money, they still have to sign a disclaimer or an assignment. They still have to do something. They can't do nothing. If they do nothing, the executor really has no good options. They can ask the court to hold the funds in the registry of the court, but it turns into kind of a really big mess.
Yep. I agree. So we don't want them in our estate plan. We know the dollar is a bad idea. We know putting them in the will is certainly a bad idea. The trust, not a great idea either if we have someone we're trying to estrange, someone who doesn't need to be included, but they want to give them something because we know we're all parents and that's sometimes what we do. So what's a good solution?
Sure. So a practical solution, which I wouldn't say I recommend for everybody, but we could talk about, just in your individual situation. Sometimes what you do is not list them in the will, but think about what you could leave them as a beneficiary on. So let's say I want Johnny to get $10,000 and that's it. Open a $10,000 CD at the bank, list Johnny with all the information you have as the beneficiary, leave him out of your estate plan then. Yeah. So then Johnny himself has the ability to go into that bank independent of your other kids and your executor. They, in fact, cannot do anything with that account. He can go in and claim it on his own, has to have no contact with anybody. Nobody else has to contact him. And if he doesn't, after the period of time under the bank's rules, they'll send it to the state to be claimed by him through Texas Unclaimed Property.
Blended families, I've seen that a lot. Sometimes that second marriage is hard on the children, the adult children from the first marriage. Sometimes those kids have launched and don't need their funds. A lot of different scenarios here, but I've seen some people say, okay, you're my current family. I love you guys. I'm going to leave everything to y'all, but we are going to set up this special account. If we need the money during life, we'll use it. If we don't, then it will go to those children or those folks from before marriage.
Yeah, and we're certainly not advocating to cut anybody out of your will. We just don't want you to be frozen into inaction because if you die without it, Texas writes it for you. And so it is better for you to make a decision that you reserve the right to change later and understand how it could all work together in a way that is getting your wishes accomplished and also being respectful of the kids that will be around to handle those things when you're gone. So
I hate to say I've seen a bunch of cases where a child has got a drug addiction problem, has become homeless, has basically disappeared, and what leaves the other surviving children or the other children of mom and dad in a real lurch that when you die, if you don't do your planning, they're in a world of hurt because Texas law says that child's a 1/3 owner and they are going to have to figure out what happened to that child, how to involve them, and get their consent to do things.
Sure. Yeah, that's a good point. Sometimes when you can't find that kid, you need to make sure that you have even just a will in place so somebody can be your executor to sell the house on their own. Because if you don't, that kid that's maybe transient, that kid that's in jail, that kid that's on drugs, you got to find that kid to be able to sign to sell real property. And that can be real difficult.
I've seen a bunch of folks tie their properties up because they can't satisfy the title company because they can't get the other third person to consent.
Yeah.
It's tough.
Yeah. So, what to do if you have an estranged child or maybe just a difficult child? Maybe not estranged, but maybe just a special circumstance child. Need to consider, of course, what you want to leave them, but that's always up to you, and you can always change it. You might consider doing it in a trust versus a will, so that's a little more private, so that you can be honest about what your wishes are. And then we need to consider the burden that we're leaving on the agents that you have later, executor or trustee, so that we're not putting them in an unfair situation as well.
Yep, absolutely.
Yep, I think that's all we got.
Thanks, Sean.
All right, see you next time.